Hello everyone, welcome to Bar and Bench. Today we will have with us Vikram Hegde sir, who is a lawyer practicing in the Supreme Court of India and other courts and tribunals in Delhi. Before we begin the interview, I would like to mention that the central government on June 21 has notified the Public Examination Prevention of Unfair Means Act. The law aims to tackle the pervasive issue of cheating and unfair practices in public examination. So let us get back to Vikram sir, who is going to provide insights into the implications and effectiveness of this law. Thank you for joining us, sir.
Yeah, welcome.
First question is that what were the gaps in the existing law that the Act now addresses?
So, on the one hand, if we look at how these offenses, the general offense of question paper leakage and cheating in examinations was being prosecuted prior to the coming into effect of this law, it was under sections 406, 409, and 420 of IPC that pertains to criminal breach of trust by a public servant or agent, and cheating respectively. And the punishment in those cases, in 406, it is imprisonment up to 3 years. 409, the punishment is imprisonment up to life imprisonment or 10 years. And in 420, it goes up to 7 years. So in a sense, perhaps the offenses that are prescribed under this act and the punishment that is prescribed under this act is lesser, because it goes only up to 5 years for members of the general public, and for service providers, that is where a heavier penalty has been imposed, where it can go up to life imprisonment, or it can go up to 1 crore fine also.
Okay, sir. Okay. So my second question is, what are the areas that haven't been adequately addressed in the new law?
In a general sense, the law is directed only towards punishing malpractices. There is no other positive measure that these public authorities are enjoined upon to undertake to ensure that this sort of cheating in examinations does not take place, or at least the possibility of such cheating in examinations is minimized. That is one larger drawback, I would say. The other drawback that can be identified is that there are some specific kinds of cheating which is very common and which is well known, which perhaps has not been covered under the definition of unfair practices as defined. Though, of course, I would point out over here that it is an inclusive definition and can be done. To give an example of one such practice, I would say impersonation. We've had cases where there are persons who, for money, they pretend to be one of the candidates and go write the exam on their behalf. Typically, these are people who have been successful in the very same examination previously. Now, in all these situations, we are, while we can cover it under the definition of practices, it is not specifically covered under this act.
Okay, so my next question is, while the Act contains an exhaustive list of what constitute unfair means, is there any mechanism to prevent such unfair means in public exams?
No, so that is one of the major drawbacks of the Act, insofar as other than prescribing punishments for it, there is no protocol that is laid down in terms of what are the basic safety measures that all these public exam authorities that have been named in the first schedule to the Act, what are the things that they should take? What is the sort of strong room procedure that they should maintain? Maybe they can be prescribed by rules made thereafter, but at least some sort of indication of all of these things could have been given in the Act, which would have sort of some guidelines and at least given a benchmark for all these authorities to meet.
All right, so the next is that the CLAT and other entrance exams for government law universities, they do not currently come within the ambit of this Act. So do you think they should also be a part of this Act?
If we look at the entire scheme of the Act, and particularly some of the provisions which pertain to the fact that this can be a model draft for the states to adopt, it becomes apparent that this act is geared towards covering only the central government examinations or examinations that fall within the purview of the union government. Now, CLAT is a consortium of law schools which are created by the respective statutes of the various states. And for that reason, perhaps CLAT would not fall within the definition of these public authorities or would not fall under the scope of this legislation. That said, since this bill seeks to be a model for states to adopt, where as in how they deem fit, it can later be brought at a different point of time, perhaps in a slightly different manner.
Lastly, I would ask that do you see that enforcement of the act decreasing the litigation that goes directly before the High Courts and the Supreme Court?
This act, I think, is good only for handling individual cases of cheating. It does not take into account the large systemic impact of an instance of cheating. For example, if we take a look at the cheating that is alleged to have taken place with the NEET examination, there are supposedly some exam centers which compromise the process. Now, maybe the administrators, those at examination centers would be punished or would be prosecuted under this legislation. And maybe the individuals responsible for such cheating would be prosecuted under this legislation. That still would not change the fact that the wider examination has been compromised, and at a larger level, the lakhs and lakhs of students who wrote the exam, they do not have the feeling of the examination having been a fair process. To that extent, it may not reduce the sort of litigation that goes to the High Court and to the Supreme Court with regard to these examinations. The other aspect is that a lot of the litigation that goes on to the High Court and the Supreme Court is at the stage of counseling. And that involves a lot many things that is not within the purview of this legislation at all.
Okay. There is one more question that I would like to ask you, that the act is silent on who the members of the public examination authority will be. So although that will be notified on the ad hoc basis, but who should be the members of such authority? What do you think?
So I think the definition under section 2A must be read with the schedule. So that gives us an overall picture of public examinations under section 2K are defined as any examination conducted by the public examination authority as specified in the schedule or conducted by such other authority as may be notified by the central government. And then public examination authority means an authority specified by the central government. So now this read with the schedule gives us an understanding that all the authorities mentioned in the schedule are also public examination authorities. Entry 7 of the schedule is a residuary clause, such other authority as may be notified by the central government. And if we look at the schedule, they are all authorities which conduct examinations to either services or educational services, which educational courses which are administered by the union government or at the union government level.
Okay, so all right. Thank you so much for joining us and giving us this insightful interview. And thank you.
My pleasure.
Subscribe to our YouTube channel and click the bell icon.